My name is Gail Horowitz. I am the president of the Northeast Ohio chapter of the American Constitution Society. We are a co-sponsor of this event with CASE, and we're so thrilled to be able to do so. The American Constitution Society is a national organization that is comprised of lawyers, judges, law students, really anyone who's interested in learning more about really important issues of civil rights, constitutional law, and public policy. We have a program about once a month. Typically, they're free, and we really encourage everyone to check our website, acslaw.org, and try to get involved with us. There's also a law student chapter right here at CASE. Next month, we'll be co-sponsoring a great event with them, a Supreme Court preview. And if you guys grab the green sheet on your way out, you can read a bit more about that, and we hope that you'll all attend. It's over at the law school. Real quick, I just want to make mention of anyone who's here to get CLE credit. This is the form that you need to fill out. It's a white form, and it's at the table at the back. So please be sure on your way out that you fill out this form and leave it on the table, okay? There's no other way to get CLE credit. So if you just signed your name in, that's not gonna work. We need you to fill out this form, so please be careful about doing that. So without further ado, thank you again for coming, and I'd like to turn it over to Professor Hill.
Hi, my name is Jessie Hill, and I'm an associate professor here at the law school. And I am extremely pleased to introduce our speaker tonight, the Honorable John E. Jones III of the U.S. District Court for the Middle District of Pennsylvania. Judge Jones began his legal career in private practice in Pottsville, Pennsylvania, and worked in private practice until he was elevated to the federal bench. He was appointed by George W. Bush in 2002. Even before becoming a federal judge, however, Judge Jones had served the public in a number of ways, including as a Pennsylvania state attorney, the Pennsylvania state attorney for the DARE program, Drug Abuse Resistance Education, as well as a member of then Pennsylvania Governor Tom Ridge's transition team. And then Governor Ridge subsequently appointed Judge Jones to the chairman of the state's Liquor Control Board. And he's been very active in alcohol education as well at the national level. Judge Jones is a graduate of Dickinson College and the Dickinson School of Law of the Pennsylvania State University. He also holds an honorary doctorate in law and public policy from Dickinson College, which recently recognized him as one of its 25 most influential graduates. His other honors and recognitions include an honorary doctorate in law from Muhlenberg College, recognition from Time Magazine as one of the 100 most influential people in the world, the Rave Award for Policy from Wired Magazine, as well as the first ever John Marshall Judicial Independence Award. Judge Jones has presided over a number of important and high-profile cases, but for our purposes here today, of course, the most noteworthy is his 2006 decision in the case of Kitzmiller v. Dover Area School District, in which he ruled that the school district's attempt to require mentioning the theory of intelligent design in public school classrooms as an alternate to education, evolution, violated, Freudian slip there, violated the separation of church and state required by the First Amendment of the Constitution. Since this was the first test of the constitutionality of teaching intelligent design in the public schools, and since the case also proceeded to a full-blown trial, of course, it garnered an enormous amount of media attention. But it's almost certain that the case and the opinion would not have received as much national attention and praise and continuing interest as it has had Judge Jones not written such a thorough, careful, and judicious opinion. The opinion's skillful explication of both constitutional doctrine and the scientific evidence, as well as its eminent readability, have attracted the admiration of legal scholars and scientists alike. And as well, I think it demonstrates the quality of open-mindedness and judicial independence. And I think some of this judicial independence in particular is going to be the discussion of some of Judge Jones's remarks, so I'll stop my introduction of him there. I do want to take a moment just to mention that this lecture is, of course, a part of the Year of Darwin celebration this year, since 2009 marks the 200th anniversary of Charles Darwin's birth and the 150th anniversary of the publication of On the Origin of Species. I would like to therefore thank all the members of the Darwin Year Planning Committee, which is an ad hoc committee of individuals from across the university and its many departments, but especially Neil Greenspan, who has worked tirelessly and for free to make this extraordinary, really amazing series of events happen. I also want to acknowledge our co-sponsor, the American Constitution Society, and of course Gail, who you just heard from, for both their generous financial and logistical support. Gail has an enormous amount of energy and commitment, and she brought that to planning this event like everything else she does. One other announcement I've been asked to make. Tomorrow, there are more events related to the Dover trial. There is an event entitled The Devil in Dover and Elsewhere with Lori Lebo, whose book is available for sale out front. She's the journalist who covered the Dover trial, one of the journalists, for the local paper, and the author of The Devil in Dover. And then Richard Katsky, who is here as well tonight, and he's the attorney from Americans United for Separation of Church and State, one of the attorneys who tried the Dover case. That is tomorrow, so that discussion will be tomorrow at 12:30 in Clark Hall, room 309, and it is free and open to the public, so I'm sure it will be wonderful. So I will turn it over without further comment to Judge Jones.
Thank you so much, Jesse. Thank you, Gail. Thank you to the Society for having me, and thank you for that beautiful introduction. I am truly honored and delighted to be with you this afternoon and this evening to give you some thoughts on a variety of subjects that obviously arise out of depending on your perspective, either famous or infamous case that I handled back in 2004 and 2005 and into 2006, as a matter of fact, as well. As we were walking across campus earlier today, I noticed that there were posters that were heralding my speech this evening, and Professor Hill pointed them out to me, and I saw that Charles Darwin's face is on the poster, and I said to her, I hope people don't think that's me. Now my life has been filled with some interesting events and interludes, obviously, since I decided this case in 2005, and I have been blessed with invitations literally from around the world to speak, and I enjoy this. I think this is something that we should do as federal judges, and we need to talk about the rule of law, judicial independence, the Constitution of the United States, and the need sort of concomitantly for a better civics education in the United States. And I'll get to some of those topics in a bit. I will tell you that as gratifying as this has been for me, with some speed bumps along the way that we'll talk about also, it also has these entirely surreal turns that my life has taken. And to give you just one quick sample, I come from eastern central Pennsylvania, the anthracite coal region. I'm truly a small town boy, and you couldn't make up some of the things that have happened to me over the last couple of years. And I think of one that happened last year. Some of you may have seen a documentary that Nova did on the intelligent design trial. I commend it to you if you're interested in it, and if you haven't seen it, they'll rebroadcast it, I think, next year on Darwin's anniversary. And they asked me, they said, would you do any appearances in connection with this? And it was entirely well made. And I said, well, within my limitations and ethics, I said I would be happy to consider these things. So one of the things that we did is they took us to New York, and we went to the Carlisle Hotel, and they had this panel of experts and folks, some affiliated with the trial, some not, and it was moderated by Sir Harold Evans, who's a very esteemed journalist, was an editor of a major newspaper in London. So this is a kind of a big deal setting. Well, they had invited folks from New York to a reception afterwards, and I'm standing there, and this woman walks up to me. You can't imagine where you find yourself after doing something like this. And as the woman is getting closer, I look at her and I think, I can't believe it. And then she gets closer, and it's Kathleen Turner, the actress, who apparently had an interest in this. And she comes up to me, she said, "You know, Judge," she said, you're a particular hero of mine after deciding that case. And I was momentarily rendered speechless, but all that was going through my mind at that point was that scene from Body Heat with Kathleen Turner. Or for you younger visitors, Jessica Rabbit, But so I've had some interesting things happen to me. But to turn to a more serious vein, I think that we need to be cognizant of the fact that if you poll in the United States today, somewhere over half of the citizens of the United States will fairly consistently opine that somewhere in the United States Constitution it is expressly stated that we are a Christian nation. Also, if you poll, you'll find that about 15% of our fellow citizens can tell you that John Roberts is the Chief Justice of the United States Supreme Court. However, 65% of our fellow citizens, when polled, can give you at least the name of one judge on American Idol. And it's true. And if you put that in the context of what I refer to as my Dover experience, this was a case that was litigated actively over a period, as I said, of about a year, give or take. We had myriad motions, we had hearings, conferences with counsel, interim orders, and finally a 6-week trial. I had voluminous submissions from counsel coming at me from every direction. It was a very carefully litigated, workmanlike endeavor for all involved, and of course it culminated in an opinion that was longer than I wanted it to be, but as long as I guess it had to be under the circumstances, 139 pages. Now, some may believe, some in this room may believe that, and certainly in other quarters, that I got it wrong. And that's perfectly fine. That's the essence of this democracy. You're entitled to your beliefs. But I will say that they can't say that the lawyers, the parties, and this judge didn't work at it and try at least to get it right. But therein lies a lesson from litigation of this type and something about our judicial system, and that is that judges indeed, I'm here to tell you, if you didn't know this already, go about their work, their duties in a very workmanlike fashion. It isn't magic. It isn't particularly sexy. We do what we're supposed to do. We find the facts and we apply the law as we find it, particularly in the district courts and in the trial court, as I did in this case. The law in my case that was handed down by my circuit, the Third Circuit, and of course the Supreme Court of the United States. And those of you who are involved in the law, students, lawyers, otherwise, you of course know that. But in the immediate aftermath of my case, while of course I was gratified by some of the evaluations from various individuals and commentators, I took it on the chin from some pundits who are, I'm sure, well known to you. For example, the night of the evening of the day that I released the decision, basking in the glow of having gotten the decision out ahead of schedule, my own self-imposed schedule, which was before the end of the year, and sitting happily at home as the sort of preliminary reviews were coming in. I was channel surfing and doing what males do, I had controlled the clicker on the TV set, and to my wife's great chagrin, she's yelling at me, stop, please stay on one channel, and stop channel surfing. And there was a teaser on about Bill O'Reilly, who was going to discuss the case. Now, I don't watch Bill O'Reilly as a rule because I don't like to go to bed with indigestion when people are screaming at each other. But hubris is a difficult and sometimes terrible thing. So I said, well, I'm going to watch Bill O'Reilly, which then led to my watching balefully as O'Reilly kicked the stuffing out of me with his friend Judge Napolitano for the first 10 minutes of the program, and ended this exchange by saying, Judge O'Reilly looked at Napolitano, he said, here we are, 5 days before Christmas, and we have another federal judge taking away your civil liberties. And they shook their heads sadly. And what an idiot I had been in this case. And I quick turned the TV off. I looked at my wife and said, shouldn't have watched that. So that's how I ended my day. Then in the period after that, Pat Robertson, the Reverend Pat Robertson, said that it was likely that a catastrophe would befall the town of Dover because of their highly unreasonable choice to unelect their school board, and I began to wonder if I was going to get hit collaterally by that damage. Dover is still there. I'm still here. You might want to stay a couple paces away from me after the lecture. Phyllis Schlafly. That's kind of generational. Not a lot of people remember Phyllis Schlafly that well. If you get around, Phyllis Schlafly was a great conservative firebrand in the 60s and 70s, and is not quite so well read today. But Phyllis Schlafly wrote a column, and it was called Judge's Unintelligent Rant Against Design. And in it she said, and I can almost quote this verbatim because it gets seared into your consciousness when you see it, she said that John Jones was appointed to the federal court by George W. Bush, who owed his election to evangelical conservatives, and as a reward for that, Jones turned around and stuck a knife in the backs of those who brought him to the dance in deciding this case. And finally, the coup de grace was administered some months later by Ann Coulter, who what is true in her book Godless, that was published that spring. And I discovered this quite by happenstance. You haven't lived till you've been in a Barnes & Noble and you realize that there's a book in the front of the store on the bestsellers table in which you're eviscerated. She said that I was a hack, that I didn't understand the law, and that we hadn't had a First Amendment scholar near the bench like this since Harriet Miers almost made it to the Supreme Court. So you can tell she didn't like Harriet Miers apparently either. Now, these things are tough to take, but it goes with the territory, but they're very instructive, and they shared, in my view, a common element, and that is that too often, and of course, pundits will be pundits and commentators will be commentators, but there was a considered neglect and an omission that was evident. These people don't explain how judges work. And it's on us, I think, too, that we don't talk enough about, as I said, how judges decide cases. I think they know better, obviously, and they tend to demagogue these things for their own purposes. But I think we need to talk about how the world really works as opposed to how they think it should work, some of these folks. And it is debilitating, I think, in our system of government, and particularly on the judiciary, if we don't do that. Consider, if you will, another case that was decided not long before my case, and that's the Terri Schiavo case. You all remember that. It was certainly in its time at least as focused upon, if not more, than my case. I happen to know the district judge who decided that case. His name is Jim Whittemore. He's from Florida. And you remember the essential facts of the case, but what happened was Congress hastily passed a law that mandated federal involvement in a case that really was, I think most feel now, quintessentially a state issue. Judge Whittemore was faced with an injunction. He had to review, among other things, whether or not Terri Schiavo received due process because of this legislation and all the things that were done through dozens, literally dozens of judges that had the case before he did in the state court system, and he decided that Terri Schiavo, that what took place in the underlying state action passed constitutional muster as to Terri Schiavo and her family. Now, as you well know, Terri Schiavo subsequently passed away. And by the reactions that this engendered, you would have thought that Judge Whittemore and the other judges pulled the plug on the respirator when they, my view, decided that case properly, carefully, and according to the law. And it invited a lot of criticism of the judiciary, who these judges think that they are, deciding life and death issues. And of course, we do that in the judiciary. We are tasked to do that occasionally. Judge Whittemore suffered a similar fate to what I have gone through in this case, and it was something that was totally unexpected to me, which is that for a period of time after he decided Schiavo, and for a period of time after I decided this case, we both had to have round-the-clock United States Marshal protection because of threats to us and to our families that we received, which is a little bit of a sad statement about the way things work in the country. So, and he's an unfortunate kindred spirit in that respect. So that prompts the question, I think, why is this happening? Why have we arrived at this point? And I think you have to go back first to look at some of the examples I gave a couple minutes ago, how bereft I think we are of a good civics education in many quarters, and for our purposes this afternoon, particularly how we lack an understanding of how the judiciary works in the United States. The American public, simply stated, does not have a good grasp of how judges operate, and you take that sort of lack of understanding, and as I said, I blame the judiciary, incidentally, for that, because I don't think we talk about this enough. It's not totally on us, but we have a role to play. And then you put an overlay on that of this 24-hour news cycle, and you all know that it exists, and the punditry that sort of whipsaws people back and forth. And I don't mean to make this left-right. I don't do politics in particular, but you all know what I'm talking about. You have folks who have their favorite pundit, and I find it's confounding, and they'll quote them every day. They'll say, well, you know, Rush said today, and then what comes out is what they think the world is supposed to be. And it can be, you could watch Rachel Maddow, I suppose, on TV now and say the same thing on the other side of the equation. We don't have broad-based, I think, sources of news. News has become more opinion, I think. That's a personal viewpoint, but it does cause this synergistic result where I think it dumbs down portions of the American public and leads to an even worse situation as it comes to understanding our government, and as I said, in particular, the judiciary. If you look in particular at my case, and the perhaps one of the seminal issues in my case, and back to sort of polling, you'll find that in the United States, if you poll today, and Richard Katzke, who is one of the very, very able attorneys for the plaintiffs and who's speaking, as was noted tomorrow, knows this well, about 50% of our fellow citizens believe that creationism should be taught in place of evolution, or should be taught alongside of, or some form of it should be taught alongside of evolution in our schools. And so that gave rise to a belief on the part of a public that doesn't necessarily understand the rule of law and the way the judiciary operates. They said, well, why doesn't this judge, and then sort of the pundits fed this as well, as I said, why doesn't this judge get with the program? Why doesn't this judge do what the public wants? Why doesn't this judge allow this policy in Dover High School that injects intelligent design into the 9th grade science curriculum. Well, you know, those of you who are, and I suspect you are all here because you are enlightened citizens, and I'm preaching to the choir to a certain extent, but and particularly those who are lawyers, that we have this thing known as the Bill of Rights, we have the First Amendment, we have the Establishment Clause within the First Amendment, and we have literally generations of jurisprudence that has to do with the Establishment Clause and tests that we apply as judges when controversies of this type come up. But in the face of that, we have an American public that largely believes that the judicial branch is a majoritarian branch. Now, you know that we're not, and yet that's lost. So the public thinks that we're like Article 1 and Article 2 of the Constitutions, creating, you know, respectively the legislative branch and the executive branch. They are directly responsive to the public. They are majoritarian. They sit in popular elections. They're designed to be on the ground and reflective of what the public wants and needs at any given time. But Article 3 was expressly designed by the framers to be non-majoritarian. Judges are responsible not to the popular will at any given time, but to the Constitution, the Bill of Rights, and to the law of the land. And what I suggest to you, what I submit to you that we have to do as law students, as lawyers, as interested and engaged members of the community, which I'm quite sure that you are, and again signaled by your presence here today, is find a better way to express how our system, which I think is the best system of the world, and that's a conceit, I suppose, but I truly do believe that, how that system works. And I want to reflect for a moment on that document, that wonderful document, which is the United States Constitution. Now, over the last couple years, and I joked about this poster with old Charles Darwin's face on it. He was a interesting looking character. I hope that I never get to look quite like Charles Darwin as I get into my dotage, but I know that I'm inexorably linked with Charles Darwin, and probably will be for the rest of my days. I don't know how my case will withstand the test of history as time goes on. I know I probably wrote the first line of my obituary, but I also know that we're coming up on the 200th anniversary of Darwin's birth and the anniversary of the publication of Origin of the Species. But think for a minute and go back to 1831. Charles Darwin at that time was still a very young man and hadn't yet arrived at the point that he would in his endeavors and labors that would make him so famous. But there was another young man at that time who traveled to America to research what would become a seminal work, and it was called Democracy in America. And some of you may be familiar with that in your studies. That was Alexis de Tocqueville. Now, some of de Tocqueville's observations that were made about 170 years ago, if you go back and you look at them, I would suggest they're terribly insightful and they're eerily prescient as we reflect on where we are in 2008. He recognized, this man of Darwin's time, that ours was an imperfect system of government. But he said this, and I would quote from Democracy in America: "In examining the Constitution of the United States, which is the most perfect Constitution that ever existed, one is startled at the variety of information and the amount of the discernment that it presupposes in the people it is meant to govern. The government of the Union depends almost entirely on legal fictions. The Union is an ideal nation, which exists, so to speak, only in the mind, and whose limits and extent can only be discerning to the understanding, Eerily prescient, I think, as we look at where we are today. And I think Tocqueville recognized the necessity of our citizens to be engaged and to understand the rights and privileges that flows from the Constitution, and that's a challenge that we have. He apprehended long ago what, again, is sometimes lost today. That is that we have a system of checks and balances. And in particular, our judiciary, as you know, was designed to protect against the tyranny of the majority. And that means at any level. Consider, in the context of the Kitzmiller versus Dover case, that in this case, you had a group of parents who coalesced together and in the face of very daunting odds, obtained counsel and had their constitutional rights vindicated in a court of law. That would not happen, folks, as you know, in most countries across the world. No shots were fired. No one died. The case was decided, I think, as it should have been and as the framers intended it to be, and as Tocqueville thought, I think, that the Constitution was designed to work. He also admired the Constitution not only as an ideal, but recognized that its essence was not easily modified based on the whim of the people at any given time, which is sort of an extension of that non-majoritarian aspect of the judiciary, isn't it? When you think about it, over the 221-year history of the Constitution, there have been over 10,000 attempts to modify it by amendment. Only 27 have succeeded. So there's a certain lasting durability to the Constitution that probably exceeded the framers' wildest expectations and dreams. With all the admiration and study of what was to him, what was to Tocqueville a most vexing, but at the same time a compelling and fascinating and noble country, he worried about our long-term survival and our quest for equality. In that vein, this is the last sentence that he said in Democracy in America, which is sort of a heavy-duty work and a little ponderous at times, but you can extract some pearls from it. He said, "It depends on themselves whether equality is to lead to servitude or freedom, knowledge or barbarism, prosperity or wretchedness." Words I would suggest for our time as well. Last week I had an opportunity to spend some time, as I do occasionally, with a Supreme Court justice. And I've had the great good fortune to meet several of them since I've been privileged to get on the federal bench. And last week it happened to be Justice Alito. Now, you may, in your daily lives, agree or disagree with the works of individual Supreme Court justices, but they are all fascinating and interesting people, and occasionally fun to be around, and always stimulating to talk to. And in the small group that we were in, Justice Alito told us during our exchange with him that he's never driven by his headquarters, the magnificent building that houses the Supreme Court in Washington, nor has he walked up the front steps of that building without focusing on, and then he's been on the court several years now, without focusing on and being transfixed by the four words that are engraved on the edifice, and they are equal justice under law. And he said that he shares that with all of his other colleagues on the court who are transfixed by that, no matter how long their service, and as you know, some of them have served literally for decades, they're moved and inspired by that passage. We should reflect on that too, the beautiful simplicity of those four words, and how we should cherish, I think, a judiciary that does, in the main, I would suggest, what it is supposed to do. We can get it wrong. We are deeply imperfect at times. That's why they have appellate courts, and we can get reversed, and believe me, I have been reversed. I'm far from perfect. But I'm here to tell you that we work in every instance to get it right. I do, my colleagues do. And I want you to understand that as you think about what we do. We, I believe, are upholding the ideals promulgated by those wise men who assembled not that far from here in Pennsylvania, in Philadelphia, about 221 years ago during that very hot summer. So if I can enlist you to be a little bit more circumspect and to consider this treasured system of justice that we have, then I will have achieved something this afternoon and this evening. As lawyers, as future lawyers, as interested citizens, members of your community, all, I would posit to you that it is your duty to work to uphold this system that we have. So I thank you again for having me, and I guess we're going to have the professor come back up, and I'll be here.
Yeah, and we have a bit of time now for question and answer. Two things. First, again, to remind you, if you're here for CLE credit, you must fill out that form, or you will not get it. It's on the tables outside. And then second, this is being recorded, so we have mics going around. There's going to be a webcast available. So if you have a question, please raise your hand, and someone will bring you a mic, and please wait for the mic before you begin speaking. Okay, thanks.
Okay, we found one back here.
Okay, they have the mic back there. He'll look at you. Go ahead.
Your Honor, given the thrust of your decision, how would any proffered expert witnesses for defendants pass Daubert muster?
Pass what muster? I'm sorry.
Daubert.
Well, they pass muster under that test in terms of being able to testify. I let them in. You know, it was not that I couldn't hear their testimony. If it was a jury trial, it might have been somewhat different. We might have had that challenge. But what I did do is I took that case, and this is inside baseball, and I know that we're not quite all lawyers here, but that case, of course, stands for the proposition that judges should be gatekeepers and should not let junk or bad science or non-science into courtrooms. But that case was instructive to me in this sense, as I determined whether, in fact, intelligent design was good science. You can extract the lessons of Daubert. Is it testable? Is it generally accepted? Has it been peer-reviewed, and so forth? And so it was helpful there. But I heard the defense witnesses. They all, the ones who wanted to testify, testified. I might not have accepted as scientifically sound their testimony, but they were not barred from testifying.
Question I have, I was so thrilled when I read the results of this case. I didn't really think I was living in the same country, but did you ever get any feedback what the Bush administration thought when the person that they'd appointed did not exactly follow the script that they had in mind?
There was, right about the time I decided the case, that the president's science advisor commented publicly, and Richard may remember his name, and I don't remember his name. Okay, he said publicly that he was gratified by the decision, which was interesting in light of some statements that the president had apparently made prior to the case about intelligent design. But no, you know, we're, as we were talking about this earlier today, you know, the beautiful thing about the Constitution and Article 3 and the appointment of judges who are confirmed and serve for life, so long as we behave ourselves, is that we're untethered from the mothership. You know, we don't check in with a benefactor, and again, that's something that is lost. And in the same vein as I just discussed, there are many members of the public think that we are, you know, constantly beholden to those who got us there, and that we have to adhere to their whims and their philosophies. Well, we don't. So I've never. I don't know, and it wouldn't matter anyway in terms of my decision, but I think it's probably like everything else. Some liked it, some didn't like it. The criticisms came in the main from you know, quarters outside government, more from the sort of punditry as I described it.
Your Honor, You mentioned that in polling, 50% of Americans don't, believe that Christianity is part of the Constitution. As a scientist, and coming from, this case from a scientific point of view, if you do similar polls, you can find that 50% of Americans think that the sun goes around the earth or the earth is flat, which are, demonstrably wrong. Maybe a little bit harder than actually looking at the Constitution. So you mentioned that education is important. Now in science, there's, lots of education that's supposedly out there, yet there's still all these misconceptions in the populace. So what mechanisms would you suggest in, say, law, in civics for education, and then perhaps how can these be extended to other fields?
In Pennsylvania, we have a wonderful initiative that's started by our First Lady, who also happens to be a federal judge herself. Midge Rendell is a Third Circuit judge. It's called Pencord. And what it does is it tries to give teachers some tools, because it's really not on the teachers. It's what school boards mandate. It's what the curriculum is designed to be. And I think the theory is that we've gotten into sort of a world cultures educational opportunity for people, but we don't do enough bedrock civics education. Sandra Day O'Connor, former Justice Sandra Day O'Connor, is working very hard in this area as well. So I don't think that it's magical. I think it's really as Sandra Day O'Connor says very frequently, this is not stamped on our genetic material. It has to be learned and relearned, and the sort of good bedrock civics education. I think maybe there was an assumption. I'm not sure about this, and I'm not an expert in teaching by any means, and I don't mean to hold myself out as one. But I think there was sort of an assumption that people got this, that you sort of, gee, everybody knows how government works. Well, they don't. They don't really understand it. So I think we have to amp up and sort of develop a curriculum that pays some real sincere attention to the American system of government, all three branches, the Constitution, and so forth, because it's really been lost. And the corollary is that if you don't understand, if you don't have a basic understanding of the law in particular and how our system works, well, what's going to happen? You're going to be at risk of losing your rights, aren't you? Or having someone do something that is deleterious to those rights. So it isn't just that we ought to know better and we ought to respect the system. It goes right to the individual. We need to know what the rights and privileges are that we have as citizens in a democracy.
I was curious, supposing a school board somewhere decides that the students should be taught some really nutty idea that does not have a religious basis, so cannot be thrown out on establishment grounds, would the parents of the children have legal recourse to say that we don't want this taught? And the question, I was intrigued because in the Scopes trial appeal to the Tennessee Supreme Court, one of the attorneys, Arthur Garfield Hayes, suggested that teaching a ridiculous idea in schools would be a violation of the 14th Amendment strictures against unreasonable laws. I was wondering, that case got punted, but I was curious whether whether parents would have any recourse under the 14th Amendment, say.
Well, stupidity is not necessarily unconstitutional. I mean, I sound flippant, but it's true. So I. One of the lessons that came out of the Dover case is be careful who you elect to your school board. Truly, you need to keep your eye on the ball and ask some pertinent and careful questions before you cast your vote. I would think, in retrospect, the citizens of Dover, may still, some of them, be beating themselves up that they let this happen. I don't think that school board ran on this kind of agenda. I think this was sort of below the surface, and it's what they wanted to do. But in terms of something that's not constitutionally infirm, state boards, local boards, will do what they want to do. That's democracy. You want to watch who you put on these boards. The
Military Commissions Act of 2006. Do you think that act is constitutional?
I'm not going to give an opinion on that. I don't want to. No, I can't. I mean, I'm not going to give an advisory on something that's not in front. With all due respect, I mean that's where I have to not tread into.
How about the military judges? Do you think that they have the same commitment to equal justice under the law that let's say you have?
Oh, I don't work with military judges, and it's a dangerous territory for me to get into. I don't know why they wouldn't, but that's a perilous area, and I apologize. I just don't want to. We ought not. We can't, as judges, within the ethics and the rules that govern what we do, venture opinions on cases that aren't before us and that haven't been decided. So I won't tread into that area.
Would the public be better educated about the federal courts if television cameras were allowed in? And do you think that they would have been better served if your trial had been televised?
Yes and yes. Yeah, absolutely. Yeah, I was telling Professor Hill today that a couple weeks before the trial started, I received a motion to intervene from Court TV. It was then Court TV, and I forget what it's renamed now, but they wanted to televise the case wire to wire, and there's a very strong predilection against televising cases in the federal courts. I'd been on the bench 3 years at that time, and I thought, this is going to look like a tremendous grandstand. And we also had a local rule in our district about televising it, and they filed. I denied it, and then they filed a motion to reconsider. And I thought, I wonder, if I should maybe take the bold stroke. I joked with people later, for those of you of a certain age who remember, most of you, it looks like, the O.J. Simpson trial. I couldn't get Judge Ito out of my head, and I thought, seriously, you're not sure. You think about not just the lawyers interacting with the TV cameras, but you wonder how you'll come up. But that wasn't really the calculus. It was that it just wasn't permitted. In retrospect, and having now been 6 years on the bench, we're going to get TV cameras, and we should. I know that there are people in the federal judiciary who disagree with it. There's no reason not to. They're very unobtrusive. The lawyers don't play to the cameras in other courts that I see. I think that you'll see them legislated in a way that gives the trial judge some discretion, as you should have in a case where, for example, you have a victim, whose identity shouldn't be published or disclosed, are very sensitive cases. But why not? Why not? I think it's an excellent educational tool, so I'm all for it. Now, there are some members of our Supreme Court, who are very much against it, but I think we're going to move pretty rapidly. I'd watch for that in the next year or two. I think you'll start to see that. I certainly am for it.
Hi. Mine is a comment ending in a question. I teach human evolution at the university level, and to my surprise, but also supported by polls of over 50% in some instances, people in the United States believe in angels and UFOs. So my comment is, what do you think about teaching critical thinking skills?
Well, I don't, I would assume that education is about teaching critical thinking skills. I mean, isn't that the essence? My wife is a former school teacher, and I thought that's what you do, and I think you try to do, to be fair. But we're just I lament that. I think our minds just get excessively closed in the United States. That's my personal commentary. That's not in any official capacity. I think people need to reach out and see different points of view. I think that helps in terms of critical thinking. Read a newspaper or two every day. Get your news from diverse sources. If you're locked on to one channel every night, I'd suggest you probably have a problem, one way or the other. You ought to be more cafeteria in the way that we consume things, but so.
Your decision obviously hinged on points of law.
Where's our guy?
Back here.
Oh, I'm sorry. Okay.
Your decision obviously hinged on points of law, but it also depended on the ability to evaluate scientific claims. Do you think most judges or federal judges have sufficient scientific background to take on cases that involve technical level scientific arguments? And should there be some level of education or continuing education for judges, that provide background in fields that will, interact with the law?
Well, two main answers to that. No, we're not generally schooled in science, and you raise certainly a good point, but that's why we have cases that instruct us as to how we can measure whether something is good science or not, like the Darwin case that we talked about earlier. And you don't have to be necessarily trained in the science to apply that case. That said, though, we're getting now in such we've been for a long time in such a complex world, scientifically, that there are these decisions that hinge, I think, on scientific principles that require that we have some modicum of education. I benefited from spectacular witnesses, marvelous witnesses, but it's not always thus. And that could leave a judge wanting in certain circumstances. I've lectured to a group called ASTAR twice in the last couple of years, which specifically has national seminars for judges to teach them science. And I think it's a marvelous thing to do it. And it's certainly a good thing, because you don't know what the testimony is that you're going to get in a particular case. And some scientific education is a good thing. We ought to have that.
Judge, my question, and I'm going to ask a question and then comment. The question is, can you discuss a little bit how your decision has been cited subsequent to it in other cases? And the comment I had was, I watched a month or two after your decision came out at the State Board of Education here in Ohio, as your decision was brought up as a reason to reconsider what was then a voted upon but not yet implemented plan to teach the strengths and weaknesses of evolution in the Ohio schools. And your decision was brought up and said, let's reconsider it in the light of Dover. And in fact, that new language was overturned. And subsequent to that, so that's the only thing I've seen is the political citation of your decision. If you could talk about the legal.
I think it's been cited in a couple of cases in California. I'm not sure where else, where there were sort of nascent battles. Richard might know this better, than I do. But it has had, and I'm gratified by this, and I certainly wrote it with an eye to not only decide the case, but to clearly set out in summary form what I saw in the case based on the scientific evidence and the testimony that I had. And I think in Ohio, my view is that it was used as sort of a primer for those who didn't really necessarily understand what this concept was or what it represented. And of course, it's my view after hearing the testimony, but I think it did have persuasive effect. So more than being cited, I think, within decisions, it's been used as sort of a compendium for people. You may read it and you may disagree with it. You may agree, you may disagree, but at least I think till you got through the decision, not only would you be enlightened as to what happened in Dover, but I think you'd have a much better idea about what intelligent design is at the end of the day, and I wrote it with an eye to do that.
Your Honor, as someone who has attended public schools for the majority of my pre-college education, and in a rural area as well, I would like to say that I'm not surprised at all by many of the statistics you've cited about the ignorance of the American people on various subjects. And a lot of people and various libertarian institutions such as the Cato Institute and Campaign for Liberty have called for the abolishment of public schools and replacing them with the free market system. What is your stance on this? Do you find it constitutional, or do you have an opinion?
No, I'm not going to wade into that. I come here as a federal judge from Pennsylvania, not the smartest man in the world, so I don't have I don't have a view. But it's an interesting discussion to have. I don't know how we'll ever abandon the public school system in the United States, obviously, but This was about a public school. This was not about a private school. This was not about or we wouldn't have had the dispute.
Since there are rather a lot of scientists in the room, being Case Western Reserve, what advice would you have for scientists who are called upon to give expert witness?
if the lawyer who calls you as an expert witness is an astute and good advocate, that lawyer will make sure not only that your testimony is clear in the first instance, and that you talk in a way that either the judge, if he's the fact finder or she's the fact finder, or the jury can understand, but also that you prepare yourself for ardent cross-examination. I will tell you that in the Dover case, I think a failing on the defense side in particular is that at least one witness that I can think of was not necessarily prepared for the searing cross-examination that he received, and so you must be prepared. It is a world you don't know. We don't know your world necessarily, and you don't know our world in a courtroom. This is not a genteel debate. I'm very serious. That happens sort of in the halls of academe. This was a federal court with a very, very important and critical issue, and I think that if and as every issue typically is at some level in a federal court, and if an uninitiated scientist wades in without proper preparation, it's the attorney's fault, I would suggest. So you need to have somebody who's astute and prepares you for that.
Just earlier today, I read a critical review of the new Discovery Institute textbook, which is at least a little step up from a copy and paste replacement of an old book, but where they try to portray science as very inconclusive on the topic of evolution. They try and replace the Darwinian tree of life model with a special creation grove model of some sort. I think they're trying to get this passed in Louisiana State Board of Education, but I was curious if you had read it. I think it's called Evolution Explained. I didn't know if you had any thoughts on going forward with this. I doubt that they would be able to make a court case out of it, but.
For the uninitiated, the Discovery Institute is a group in Washington State, and they, I'm not sure that it's an overstatement to say that they're some of the primary drivers of the intelligent design concept. They love me to death. They're big. They'll get this on YouTube, and they'll see that I'm talking about them, which will probably warm their hearts. My view. They have since the decision was released made an industry out of launching ad hominem attacks against me, and that's fine. But I wish that they would stick to facts. It's not about me, at the end of the day. They may not like me, and they may disagree with the decision. They ought to stick to the science and the law. But no, I didn't see it, and I don't spend time worrying about the meanderings of the Discovery Institute. I mean, they had a role in the trial. It's debatable at the end of the day what that role was, but that's a matter for history. Are we?
Your speech was about evolution and biology, but you also talked about how wonderful the U.S. Constitution is. The U.S. Constitution is one of the oldest, if not the oldest, constitution in the world. Other countries which have had constitutions have revised their constitutions, not just amended them, some of them many times over. When you say that you venerate the U.S. Constitution, doesn't it sound a lot like people who say we venerate the Bible? And doesn't it sound a lot like this is something which we simply cannot change? It is the way that it is. It simply is the way it will be. Consequently, when you look at evolution and you say, well, no, the Bible didn't quite get it right 2,000 years ago, is there perhaps a chance that the U.S. Constitution didn't get it right 200 years ago, and that maybe it might eventually need to be revised?
Well, it can be revised.
It's an evolutionary document.
No, I understand. It can be revised through the amendment process, and there is that great debate that always occurs. If you brought Justice Scalia in here and you said that, and someone said that they believe that the Constitution is a living document, Justice Scalia would have a seizure right in front of you because he doesn't think that it's a living document. Justice Scalia adheres to, and he says this, he said the Constitution is a dead document, and you must go back to the original intent, and if it's not in there, you don't write it in, although I would suggest that it's a lot more challenging than perhaps some who say that it's a dead document actually perceive. My own view, and again, this is a personal view, I don't represent the viewpoint of the judiciary generally, is that you're on a very slippery slope when you open that can of worms and you want to redo something that I think has withstood the test of time. Yes, it's imperfect, and there are portions of the Constitution that you can cherry pick out that are embarrassingly arcane, but it's 221 years ago. I think in the main, it's done pretty well, but again, that's my personal viewpoint. I do not equate the Constitution with religion. I think that's a stretch. You may have that viewpoint, but it's no. I'm not saying that you do necessarily. Someone may, but I don't see it that way. If you go back in jurisprudence and you study the law and you think about just how durable the Constitution has been, it's marvelous. Just a quick, if you'll indulge me, I tell you the story that I mentioned this when we were talking privately earlier today with the dean of the law school, and Justice Souter was told a story to a group of us a couple of years ago about being in the Supreme Court with a Russian judge. And he was giving him a tour of the Supreme Court, and there was an interpreter there, and they went into the judge's conference room, and it has a big mahogany table, big impressive table in there, and he said to the Russian judge, Judge, this is the table, Justice Souter said, this is the table where every case that's been decided by the Supreme Court since 1937 or so has been discussed and debated before the justices voted and eventually issued an opinion. The Russian judge, this was interpreted for him, he nodded, and he said, the Russian judge said, well, Mr. Justice Souter, he said, what case do you think is the most important case that was ever decided by your Supreme Court? And Souter thought for a moment, and he said, I think Brown versus Board of Education is probably the most important case. You're all familiar with that case. And as he was saying it, as it was being translated, the Russian judge started to shake his head. No, and yet, he said, so Souter smiled, and he said, all right, you obviously disagree with me. He said, what case do you think is the most important case decided by the Supreme Court? And the Russian judge said, through the translator, he said, I believe the most important case was United States versus Nixon. And you may remember that was the case that compelled ultimately Richard Nixon to turn over the tapes that had been the product of the taping system in the Oval Office. And the Russian judge said, for those of us who were in the legal system in the former Soviet Union at that time, that your Constitution mandated that the most powerful man in the most powerful country on earth could be made to bend to the rule of law was so significant to us because that would never happen in our country. And he said, I'm still not sure it would happen in our country today. And I think that sort of, in my mind, is an example that shows the durability of the Constitution when it's at its best. Yes?
So I know that the plaintiffs' expert witnesses, the scientists, were quite brilliant, and the attorneys were very good at drawing that testimony out from them. But I wondered, on the other side... You
say that as you sit next to one of the plaintiffs' attorneys?
Indeed I do, and proudly. And I was even,
he's a modest fellow, too. You're going to embarrass him here.
He wasn't one of the ones you saw on the TV all the time, it's true. But I wondered from the other side, you heard a variety of creationist arguments, and I wondered if you found which ones, or if you found any of them impressive, or you felt that the defense's expert witnesses, or their ability to draw these out.
Oh, I'm not going to go witness by witness. If you read the opinion, I'm sure you have, you can get the sense of who I found more impressive than anybody else. And it's not
of the arguments specifically, if there were any that seemed interesting.
it's hard to go back, from time to time. I kept an open mind through the whole trial. It was not a close call at the end of the day when all the testimony was in the case. I do, to the question the gentleman asked earlier, I think that not only were they superlative witnesses on the plaintiff's side, but they were well prepared, and they played to me expertly. They understood what they had in this judge, who was, after all, a liberal arts graduate with a political science major and not a scientist, and you have to know what you're doing. I think the defendant's testimony was all over the map, and I don't think that their witnesses were certainly as well prepared. I will say that but I'm not here to denigrate anybody who appeared. It's tough, to get into a court of law and to testify, and it was a noble attempt on their part. It just, at the end of the day, didn't carry.
Last week in Britain, the Church of England made a formal apology to Charles Darwin. I'm not suggesting that could happen here, but I wondered if liberal or more progressive religious institutions in the United States, if they got together and sort of reinforced the idea of separation of church and state, made some sort of general formal statement to that effect, would that help the judiciary?
Well, I don't know if it's helpful from the standpoint of the judiciary, but you raise a good point. I'll tell you another vignette. I was at the time I decided this case, one of my kids was in high school and had a band concert. And I went to the high school, I think it was the day after the decision, and I am a Lutheran, and my Lutheran minister was there, and I hadn't seen him, obviously. It was only a day since I decided the case, and he was very helpful to me and very encouraging through the whole process. And he came over to me, and he's a good guy, good fellow, and I knew that he wasn't going to be judgmental one way or the other, but he came over and he gave me a hug, and he said to me, he said, I really hate what people are doing today in the name of religion. It was a wonderful gesture, but I've been asked to speak in many different settings, seminaries, to different religious groups, mainstream, if you will, religious groups who receive me wonderfully and have a great curiosity about this and are not doctrinaire. But because we have so many different religions and indeed freedom of religion as set forth in the First Amendment, I don't think we want to impose on any religious group the need to sort of get our backs. It speaks for itself. But I think the response from the mainstream, if you will, however you define that, religions in the United States has been very gratifying, anecdotally at least.
Well, right here. I'll admit I'm a little ignorant on this whole judge process and things like that, but I was kind of wondering, do you have a difficult time separating your kind of personal beliefs on a case versus your, the facts based on the law, your judge personality based on a case when you're making a decision? Do I? No, I don't find that I do. I think that gets inculcated as a lawyer. I was you get your training where you can. When I was a young lawyer, I was an assistant public defender. And I tried homicide cases and horrible, difficult cases where you well knew that your client, in your heart, you knew, and sometimes you knew directly that your client committed the crime. They told you that. You couldn't put him on the stand in suborn perjury, but at the same time, the quest was, of course, in that setting to make sure that your client received a fair trial and that the burden was met by the government. And taught me something about unpopular cases, although in a micro scale to what I went through in the Dover case, and it also taught me that you have to put aside those biases. I represented people who were literally, you could regard them as scum. Very, very difficult, very
unsavory people, but they were entitled to counsel, and they were entitled to have their cases put to the test under law. So you learn from those things, and I haven't found I think the essence of a good judge is you don't do that, and I give everybody their day in the court of law.
I think we have time for one more question. There's.
Yes, I'm a current student here at Case. I attended a public high school in the state of Ohio, and my biology teacher made no secret of the fact that he was a young Earth creationist, and there was one lesson in which he explicitly told us not to write anything down, and then proceeded to go off on some very unscientific statements.
Yes.
In an instance such as this, where it is an individual teacher and not the school board mandating it, what is the proper recourse, I suppose, to ensure that good science is being taught?
I guess that could ripen into a lawsuit, and I don't want to give an opinion on what I'm not here to give legal advice, but I think where I've seen that happen, that in the first instance, most school boards, reasonable, decent school boards understand or will be given to understand the law by their lawyers. And they will understand that in a constitutional challenge, and of course the Dover case stands for this, there's what's called a fee shifting, where if they are joined in a lawsuit and they lose, they could end up paying the fees of the prevailing party. And it's a straight out issue, agree or disagree on the philosophy, it's an issue of fiscal responsibility. So I would posit that most school boards don't want somebody off the reservation like that, and that should go right to the school board in most cases. And I think I think that's happened where you have a teacher who kind of gets off the curriculum and begins to interpose something that might end up being unconstitutional in terms of how it's being presented to students. All right. Thank you all. It was my pleasure.
Thank you so much.